Today, I'm going to speak about some of the key challenges and recommendations from within the Protection Order Report. So the report, Protection Order research, is based on key informant interviews with lawyers, advocates, anti-violence workers, and survivors. As well, we conducted focus groups with survivors, we had a survey for lawyers, and we held 2 roundtable discussions with advocates and support workers. We also made a series of freedom of information requests to try to better understand the enforcement of protection order breaches. Before I go through some of the key challenges and recommendations, I do want to say that, of course, there were positive findings. One of the positive findings we heard about was how the legal system professionals often go above and beyond to ensure protection order applications are heard in a timely manner. And people shared many positive stories with me about one person who really supported them and helped them have a safer outcome. And in every research project I've been involved in with RISE, I hear stories about incredible work of individuals who are doing incredible work to support survivors having to have safer outcomes. And these stories are often about police officers or lawyers, advocates, support workers, court registry staff, sheriffs, judges, and the list goes on. And I'm sure some of the people that I've heard these inspiring stories about are attending the webinar today. However, despite the work of many people working within the legal system, our research has found that the family law protection order system in BC is not working to best support survivors of violence. I want to briefly touch on a few of the foundational challenges that we identified within the report before discussing some of the recommendations and the paths forward. So first, there are many significant knowledge gaps, and one of them is there is a really big misconception that non-physical violence is less serious than physical violence. And of course, severity and risk of violence are always going to be determined on a case-by-case basis, and protection orders are intended to be available for family members at risk of family violence. Family violence is a legal definition. Zara has pointed out that it is broad and includes many forms of violence. And many of you will be very familiar with the concept coercive control. So coercive control involves continuing acts or patterns of acts such as threats, humiliation, intimidation, and that perpetrators use to attempt to control survivors. And it does not necessarily include acts of physical violence. So when the focus is only on physical violence, it often misses the broader pattern of violence, as well as diminishes and ignores all other forms of violence. Of greatest concern, patterns of coercive and controlling violence are a known risk factor for intimate partner homicide. And it is noteworthy that within our research, key informants felt that coercive and controlling behavior was treated as being less serious than physical violence. So what does this mean for protection orders? It means that key informants are telling us that clients come to them and tell them that their lawyer has advised them that unless they have the history of physical violence, they should not apply for a protection order. Of course, this is not always the case, but this was a huge theme from our project, that without an incident of physical violence, people are very unsure whether or not they will receive protection orders. Also, lawyers themselves who we interviewed were very candid and said that in some situations, they also wonder, should they make an application for a protection order if there is not serious physical violence due to the ways that judges have responded to past applications. A second key knowledge gap is the widespread false belief that women regularly apply for protection orders to gain advantage in their family law matter. The belief underlying this is that women are vengeful and they lie. And this myth has a long history, which in summary says women are not credible when they speak about their experiences of violence, particularly if the violence they experienced was from an intimate partner. This myth was recently addressed by the BC Court of Appeal in the case of KMN, argued by Van der Nasud. So I want to pause to say that if people feel that they need to have been physically assaulted to get a protection order in family court, and if they're being asked, if they're being treated with unfair suspicion when they make their application, We simply need to do better. Protection orders aren't perfect, but they are one of the only tools available to prevent violence, and right now we've strayed a very long way from that intention. The second key challenge that we identified are a series of process failures. In some cases, these are procedural headaches. In other cases, they are logistical roadblocks, and they really undermine the entire function of the protection order system. So Vandana will speak about short-term protection orders, sometimes only 7 days, and the challenges that come from those protection orders being that short. What I want to highlight is simply that together with the knowledge gaps, as well as the procedural shortcomings, people are often asking whether or not it's worth it to apply for a protection order. And so people are saying, what if it's only for a week? Is this a good use of my resources? Because for people who don't qualify for legal aid, they could be spending thousands of dollars to get a protection order application or using their legal aid hours. And so people are asking, is this a good use of my resources? But they are also asking, will this make things worse for me? Now, anytime someone goes through a court process, of course, they are asking cost-benefit analysis questions. But this is really different. We are talking about an order that's sole purpose is to prevent family violence. And something is very wrong if people are having to ask themselves, is this going to make things worse for me? The third key challenge is the lack of collaboration between the criminal and family law systems, and it essentially really affects the entire functioning of protection orders and whether or not they're effective. The greatest area of disconnection is the enforcement of protection orders. Breaches of protection orders frequently do not lead to criminal charges, even though violating a family law protection order is a criminal offense. I'm going to switch to speak about some of our key recommendations. And overall, we recommend that a specialized process needs to be created when people are seeking a protection order. People need lawyers, and therefore we recommend that there be a dedicated protection order duty counsel to assist applicants, as well as an anti-violence advocate or support worker to help with safety planning and connecting people with resources. Overall, the process must center the safety and be trauma-informed to reflect the reality that people applying for protection orders are at risk of violence and often in very vulnerable circumstances. Reforms to the protection order regime require legal system collaboration, and we didn't simply want to write there needs to be collaboration. We really want the collaboration to be implemented, and we want there to be action. We feel that the Ministry of Attorney General has the expertise to bring together people within the legal system who are currently very siloed, including those within family and criminal law. Together, we can strategize a better path forward for protection orders because currently there are significant gaps. In our report, we write about the barriers to peace bonds, which have a significant impact on the functioning of the family law protection orders as well. We currently see that the barriers to peace bonds are essentially silent from any discussion on protection orders, and the repair of the dysfunctional peace bonds is one and the same of talking about how to move forward with protective orders. We also highlight there needs to be improvement of protection order breaches, and forever and always our recommendation for mandatory ongoing family violence education for everyone working within family law. Our hope is this report will be part of a larger conversation that anti-violence organizations within Canada and internationally are having about how best to use law to support survivors. Thank you. And I'll turn it to you, Vandana.